Welcome back to a courtroom where things sound routine until they're not. Today's docket is packed with guilty pleas, probation deals, and warnings that couldn't be clearer. One mistake can erase your freedom overnight. Watch closely. As defendants waive rights, accept conditions, and gamble on second chances. Because in this room, probation isn't mercy, it's a test. And not everyone here is passing.
Mr. Randolph, in cause number 24, DCCR 1923, you're charged with a third-degree felony offense of unlawful possession of a firearm by a felon, and that's from June 15th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Randolph's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do a pre-sentence report. Will give me more information about you, your case, and then we will come back later for sentencing. You need to stop and talk to probation before you leave the courtroom today, and she's sitting at that desk right there. All right, we'll see you back at sentencing. Good morning. Are you Albernica Conning? And Ms. Conning, you were previously in court and entered a plea of guilty to aggravated assault with a deadly weapon, second-degree felony. I've received the copy of the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, we have.
Are there any additions or corrections?
Not from the defense.
No, Your Honor.
All right, Ms. Conning, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 10 years. You are ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, the case will actually be dismissed if you successfully complete it. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sentenced to prison for anywhere in that range of punishment, which is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
Part of your probation, the conditions, is that you have absolutely no contact, obviously, with Anaya Johnson, Nikki Lawrence, Lyric Lawrence, and Deanna Darjean. Do you understand? That doesn't mean just in person. That means any contact or communication. No sending messages through DMs or any social media, emails. No telling other people to tell them things. Stay away from them. Steer clear so that you don't end up back here in trouble and going to prison over anything like this. Do you understand? Also, you are not to be anywhere near the Regent Street apartment complex in Beaumont. You understand that as well, right? Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I will be signing dismissals in cause numbers 24 DCCR 1574, 1576, and 1577 as part of this agreement. If you just need to have a seat here in the courtroom, and then probation's going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, ma'am. Good morning. Are you Christian Boutte? And give me just a second. right, and will your client waive the formal reading of the indictment in each case?
Will, Your Honor.
Did we, did I do something before on these? Somehow I have a prior version saved. So maybe I accidentally did it for. Sorry, give me just a second. I don't know why I would have done that. April 14th on,
On the indictment?
yeah, 2078 on the indictment. So, all right.
I have to go back and,
Well, do y'all want to delete one, or can you? It doesn't matter, because I'm not making any notations on it. He's pleading to the indictment, correct?
Yes.
Nothing different. All right, so, Mr. Boutte, in cause number 24, DCCR 2078, you're charged with the third-degree felony offense of forgery of a financial instrument from August 21st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? And then in cause number 24, DCCR 2079, you're also, in that case, you're charged with the state jail felony offense of forgery of a financial instrument from May 7th of 2024. And how do you plead to that charge? Speak up, please.
Guilty.
And are you pleading guilty freely and voluntarily? And because you actually did what they charged you with. In each of those cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've reached with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
And it looks like the agreement that you've reached in each of your cases, in the third-degree felony, which is 2078, you've reached an agreement for a 7-year deferred probation. There would not be a fine. There would be restitution to be determined between now and when we come back for sentencing. Is that your understanding? And in the state jail felony case, the agreement's for a 5-year deferred probation. Same thing, no fine, and then any restitution would be determined between now and when we come back for sentencing. Is that also your understanding?
Yes, ma'am.
State,
Just, sorry,
Yeah,
just to let the court know, we have discussed some subrogation documents. We just want to double check prior to the PSI that NHS, what did NHS have to pay, what did this insurance company have to pay divided. That way it's going to be pretty substantial, upwards of $60,000.
okay, thank you. All right, state tenors number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Mr. Boutte is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report that will give me more information about you, your cases, and then we'll come back later for sentencing. It'll also give everyone time to figure out that restitution for sure and who it needs to be paid to. You need to stop and talk to probation on your way out of the courtroom, and she's sitting at that desk right there. All right, we'll see you back at sentencing. Mr. Garcia, you tested positive for marijuana, amphetamines, methamphetamines, and ecstasy. Did you drive here? Oh, you're surprised about the ecstasy?
Yeah, I'm surprised about that.
Wow.
I did smoking, I did relapse a few days ago.
Yeah. All right, so I'm going to find, obviously, that that is a violation of your bond conditions. I also told you last week specifically that you had to be here on time. No, you were not here. And so I'm going to raise your bond in your case to $100,000. If you make that bond, a condition of it is that you have a drug patch on at all times, that you also have a GPS monitoring device and remain in Jefferson County, since you can't seem to get here on time. We'll figure that out. Talk to your attorney. You can go back with the bailiff. All right, Mr. Harris, this is 24 DCCR 2254. You tested positive this morning for methamphetamines and amphetamines.
I drink a lot of 5 hour powers for 3 days, and that's the only thing I think that would make a problem. I've been in Houston with my kids, and I ain't even been around here right now. And I drink a lot of 5 hour powers regularly.
5 hour powers is not going to test positive for methamphetamine.
If you send it off to the lab, I'm sure you'll see it. It's not, I don't do nothing like that. I don't even have the money for that.
Well, all I know is you tested positive for methamphetamine. And obviously there's some concern because you were arrested while this case was pending, and Mr. Coleman figured that out. Hold on.
So it was a traffic ticket.
Just hold on.
I would just observe this, if it's paraphernalia, that's a class C and normally those aren't arrestable. I mean, it is an arrestable offense, but normally it's just a ticket. So jail or fine on the offense.
Doesn't matter. If you're on bond for a felony, you should. I just asked you not to say anything else right now, okay? I'm just checking on something.
Let her check. This is right.
Obviously, Google and AI is not the end-all be-all, but it is unlikely to cause a positive result on a standard drug test. A 5 hour energy drink does not contain prohibited substance like THC, opiates, or amphetamines. Extremely rare and undetected issues involving cross-contamination during manufacturing would do it, so I don't think that's what we're worried about today. I'm going to grant the state's motion to raise your bond based on the fact that you tested positive, based on the fact that there was an additional arrest while you were on bond for a felony offense. I'm raising your bond in your case. It's currently set at $30,000. I'm going to raise your bond to $75,000. I'm going to order, as a condition of that bond, that you have a drug patch at all times, that you get it changed out as you're supposed to. Your case is still set for trial to begin with jury selection on Monday, and is everybody ready for that?
Yes, Fred.
All right, I'll number the case. If you're in custody, we'll have you brought over for trial. If you're not, then you can talk to Mr. Kimler this morning, okay? All right, you can go back with the bailiff. All right, Ms. Clayton tested negative, which is obviously good, and
No 5 hour energies.
yeah, you never know about those energies.
Stay away from.
Ms. Clayton, in cause number 25, DCCR 0446, you were previously in court, entered a plea of guilty to evading arrest or detention with the use of a vehicle. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
Defense action.
Yes, Your Honor.
Are there any additions or corrections?
Not from defense.
Not from the state, Your Honor.
What is everyone's position with regard to the recommendation in the pre-sentence report with regard to her addiction issues? The recommendation is ISF followed by JCDI program.
Again, from the defense, Your Honor, the treatment is a continuum, I suppose, and since she's demonstrated, at least today, that she's drug-free, then I would suggest the court hold the ISF in advance to just see how she progresses on probation. Maybe perhaps with a drop program.
Well, she's going to go through JCDI for sure. If, at a minimum. Mr. Nichols, thoughts since
I
she
would ask
tested
at least for
negative?
JCDI. She's still underage, but she has a drinking problem and needs to get that dealt with, treated, or under control. And she also smokes marijuana regularly. The facts on this case, she and her friend were heavily intoxicated,
Yeah.
fled from police, lucky it wasn't a crash,
It could have been terrible.
tried to hide out from police
Yeah,
around a.
I know, yeah.
I mean, it could have been a lot worse. And I'll just tell the court from reviewing the video, at least that night, they sure thought it was hilarious. She needs to grow up. She needs to take a little more serious what's getting her here in felony court.
Yeah.
And
You understand it's not funny. I mean,
I'm now going to get
no, I understand that right now, and people do
But
that.
that night, yeah, I do regret everything that night.
So here's the thing, and the seriousness of this is that if you don't do what you're supposed to and get your life on the right track, which is what everyone wants. You're young, we want you to be successful. You're gonna get a probation today where you don't have a felony conviction on your record. And if you complete that probation, you're never gonna be a convicted felon. But if you violate and you don't take advantage of the programs that we're gonna give you, it's going to be difficult because you're at an age where all your friends are going to be doing things that you're not going to be able to do. But the alternative is prison for up to 10 years. So you need to think about that every time somebody says, oh, just come on out with us and do whatever. And your answer is going to be, I'll do that in a few years when I'm not on probation, right? Because I don't want to go to prison for 10 years. So I am going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $250 fine. I am going to order that you enter and successfully complete the ISF substance abuse track, but I'm going to hold that in abeyance. That is an inpatient 90-day program. So if you get in, you're going to be required to go to JCDI and complete that program. And it'll give you the tools, hopefully, that you need to stay sober. If that's not enough and you need something more, it's already ordered. A warrant will go out for your arrest. You'll go into custody and you'll go straight to that program, okay? I'm handing you the trial court certification that shows this was an agreement that I followed. So you have waived your right to appeal. You just need to have a seat here in the courtroom. Probation will call you up when she's ready to go over your paperwork. Good luck to you, ma'am.
Thank you, Your Honor.
Thank you.
Here's the legal reality. Multiple defendants entered guilty pleas, accepted probation, and waived appeal rights all, while the judge made one thing clear. Probation is conditional. Drug violations raise bonds fast, and ignored court orders bring real consequences. Some were given structured second chances with strict supervision, while others saw their freedom tighten immediately. In this courtroom, compliance decides everything. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.